SJC-12082, Cardno, Chemrisk, LLC, v. Sherry Foytlin, and another.
Mr. Reichman, good morning.
Good morning, Your Honors. May it please the Court, my name is John Richman. I represent the defendants in this action. With me at counsel's table is James Grumback. Your Honors, it is difficult to imagine a more prototypical SLAPP suit, a strategic lawsuit against public participation. That's exactly what we have here. This action was not designed to right a wrong or to recover damages, but rather to intimidate and silence citizens of limited means who had the courage to speak up about an issue of great concern to them and their communities. The Superior Court found, and it is undisputed, that the blog was intended to influence ongoing governmental activities and court cases.
You're saying that the I wouldn't exactly call it, well, maybe it is a finding, but this is in the 12B1 ruling, is that right?
This is with respect.
It's in the motion to dismiss for lack of personal jurisdiction.
Yes, yes. So there were two motions filed, actually 3 motions filed, but 2 that are relevant here. There was one motion which defendant Foytlin made to dismiss for lack of personal jurisdiction. And it was within the context of that motion that the court found, and it's undisputed, that the blog was intended to influence ongoing governmental proceedings and court cases.
Can I ask you this? Assuming that we agree with you that Fustolo doesn't control here and that, well, just stop there. Doesn't control here, which is the basis of the decision that that Judge Liebensberger came to. Do you agree that if that were the result, there would still be a need for a further proceeding to see whether the other elements of the anti-SLAPP suit had been met?
No, not at all, Your Honor. In fact, as Your Honor, I'm sure is aware, there are 2 parts to a motion to dismiss under the SLAPP statute. One is whether there's petitioning activity.
Right, which is that was the ruling, and that's all he did, was say it's not petitioning activity, right?
Well, that's because, and this case is unique in a couple of respects. This may be one of the only SLAPP cases where a plaintiff has not even challenged that there was a reasonable basis for the defendant's statements, the second prong of a motion to dismiss under the anti-SLAPP statute. Not only did they not challenge that, Your Honors, but subsequently, after this court granted the defendant's application for direct appellant review, Chemrisk moved to dismiss their own case. And
no, I know that. I'm just, okay, go ahead.
Okay. So, and in terms of whether there is a reasonable basis, again, this was not a disputed issue here at all, Your Honor.
But I'm sorry, I mean, the standard is, 1, was it petitioning activity? You say it was.
Yes, Your Honor.
And then, if it is, the burden then is on the moving party to I'm sorry, the burden would be on, I guess, them to show that your exercise of your right to petition was devoid of any reasonable factual support or any arguable basis in law.
Yes, Your Honor.
So if they could show that the statements made here were devoid of any reasonable factual support and had no arguable basis in law, they could still proceed against you.
Yes, but they never made that argument.
It wasn't included in their motion? Oh, no, it's your motion. It wasn't included in their opposition to your motion?
Correct. It was never included.
So you're saying not that they would not that that's not an element, but that they essentially have waived it by not arguing it?
Yes, absolutely.
Okay, that was my question that I wasn't saying very well, but that's the question.
Yes, and in fact, Your Honors, there was a vast public record that would support the opinions that the defendants made in their blog. I mean, we've cited 17 different sources that back up what they said. That includes an expose in the Wall Street Journal concerning what's now commonly known
I mean,
as the
there's obviously, I mean, this is different than the standard, but there's obviously another point of view about that.
Well, I don't think there's a different point of view that there isn't a reasonable basis.
No,
for
no,
my
I'm
client's
just saying, it's just the point that the assertions made in the blog, I think that the plaintiff here would say, we can dispute them. That doesn't mean they're wholly devoid. That doesn't mean that they necessarily could satisfy the statute, but I'm just saying they're not exactly totally accepted views of the entire universe, that's all.
Well, yes, that's true, and that's the basis for their complaint, is that the statements in the blog and the opinions in the blog were wrong.
Right.
So,
If they want to dismiss this case, and I'm just trying to figure out why it's still floating around. I mean, what's at stake for you?
well, there's two things at stake. There's for my clients, there's the issue of whether they're entitled to recover attorney's fees. So that's specific to them. So it is true that they are now no longer in the crosshairs. They've been pursued and prosecuted by Chemrisk for 3 years before Chemrisk finally decided, said, hey, we're just kidding. We're not going to proceed any further in this action.
Well, they didn't say they were just kidding. They just said we wish to dismiss.
Well, that's correct.
A little bit of creative. Okay.
Yeah, that is certainly a more apt legal description of what they did. But I think the absolute unfairness of what they did is something that the court should consider. I mean, how can they go and pursue this case? Not just here, by the way. There was a prior proceeding in New York where they also sued my clients.
But what makes it not moot, putting fairness sort of in the abstract to one side, is the attorney's fees.
Well, the attorney's fees, and of course, there's a larger public issue here. I mean, this case has actually generated a fair amount of interest in the press. I mean, there have been a couple of articles in the New York Times. The AP just picked up the story as well. It's run in newspapers around the country. And the reason is that this is a really important public policy issue for the court to consider. And the issue is whether bloggers such as my clients are entitled to exercise the right of free speech, and if they're entitled to get the benefits of this very important statute that Massachusetts has.
Counsel, can I just ask you, maybe I don't really understand the difference between a blog and an article, but in this case, isn't a blog sort of a continuing commentary on different things? And here we have an article, right, in the Huffington Post. Is that right?
Well, a blog can be either, a blog doesn't by definition necessarily have to be continuing. I know my clients have written other blogs. I don't know if it's technically a continuation
All
of the
right,
same
but I'm
one,
asking,
but
why are we calling this a blog?
well, that's because that's what it's called in the Huffington Post, and because it's so clearly a recitation of what their personal beliefs are about this issue of important public concern.
When you say that's what it's called in the Huffington Post, I'm not sure that I see that here. I'm looking at the record and I see something that says the blog, but I don't think that applies to the article. I don't think it's referring to the article that's underneath it. And maybe it doesn't matter, I don't know, but you're calling it a blog.
I'm not sure that it does, Your Honor. I mean,
Okay.
the issue is, of course, whether my clients were engaged in petitioning activity, and as the Superior Court found in its findings on the jurisdictional motion, that's exactly what they were doing.
How do you distinguish Fostola?
In Fostolo, the journalist there was admittedly an objective reporter. And she basically admitted she wasn't engaging in petitioning activity. What she said in an affidavit to the court in that case is that I was an objective reporter and attempting to present both sides of the issue or the dispute in the articles that she was writing. So this case could not be more different. In this case, my clients were advocates. They were petitioners. You can read the blog or the article, however you want to describe it, and it couldn't be clearer that these are advocates. And that's just what the Superior Court found.
Did you
and it's
have a hearing
undisputed.
before the judge after the decision on the first decision? Was there a hearing where you had an argument before the judge and explained your position about why this case is different from Fostolo, or how did that come about?
Yes, there was an oral argument with respect to our motion before the court.
But were they argued simultaneously, the two motions?
Yes.
So the judge didn't exactly make findings that are binding, right, as to the question of whether or not your clients were engaged in petitioning-related activity?
Well, the court, what the court found in the jurisdictional motion was that the purpose of the blog was to influence ongoing governmental proceedings. Now, it didn't, if I may, Your Honor, it didn't obviously apply that finding to the motion to dismiss under the anti-SLAPP statute, but the finding is the
My question
finding.
is, how do we use it in terms of determining the same point? Are we to just import it and take it as a given, or do we find that analysis really stems just from papers that we're equally free to look at and can reach our own conclusions?
I would respectfully submit it's a given in this case. You have that factual finding. It's not disputed by Chemrisk in their answering brief in this case. So I don't even know the factual finding obviously was not made in the context of the anti-SLAPP decision.
Well,
It's still a finding, and it's an undisputed finding.
the second sentence of the SLAPP dismissal says reference is made to the court's memorandum and order on defendant Sherry Foytlin's motion to dismiss for lack of personal jurisdiction for the factual background for consideration of this motion.
Yes.
So the judge seems to have adopted those facts as part of his opinion in this case, just didn't reprint them.
Yes,
Are you saying the lack of objectivity in your client's activities is obviously paramount from the lawsuit itself? The fact that
Well,
they were sued for defamation?
well, I think that's what makes it so different from Fostolo. But it's not a requirement, I mean, that there be a lack of objectivity. What is clear here is what were they doing here? What was the purpose of the blog? You look at the blog itself, you look at the circumstances, and you can only reach the conclusion that the Superior Court reached, is that this was an effort to influence ongoing governmental proceedings and court cases, the very definition of petitioning.
As opposed to what Fostola was.
Right, I'm a reporter, I'm giving both sides of the story, so therefore, the court reasonably decided, well, that's not petitioning activity if you're giving both sides of the story and you're an objective reporter. This case could not be more different.
So is it, I mean, in here, of course, there's not, I gather there was nothing in her article that said, I am writing this as an advocate as opposed to as a reporter or as a scholar or as a whatever.
That's correct.
Is it your view that the holding in this case would apply essentially to any op-ed, to any editorial? Because that would be advocacy and not simply reporting?
No, I think I think it would probably apply in most, but I don't know if you could have a black line rule, because you have to go back to what the statute says. Well, what was the context that these statements were made in? Was this an effort to influence the court? Was it, or the government? Was it an effort to encourage public participation? Another element another test for petitioning. Was it designed to encourage public participation? If that op-ed did those things, then it's petitioning activity.
Okay, thank you.
Thank you very much.
Ms. Meyer, good morning.
Good morning, Your Honors. My name is Megan Meyer. Along with my co-counsel Sam Perkins from Brody Hardoon, we represent Cardno Chemrisk, LLC. Mr. Richmond threw around some accusations about what the suit was about and why it was filed and so forth. I think the record reflects otherwise. Chemrisk brought this suit because some scientists had been falsely accused of committing scientific fraud. They had legitimate reasons for bringing this suit, and now the article is almost 3 years old, and they had business reasons for deciding not to pursue it further. The record reflects that, but really it's beside the point, and those things are legally irrelevant. When Chemrisk filed this suit, Fistolo was the law of the land. There is absolutely no daylight between this case and Fistolo versus Hollander.
How can you say that?
Sorry?
How can you say that?
Well, I would say this. If you look at the facts of Fistolo, we have a community activist, co-founder of an activist organization, an anti-development organization.
Was reporting for a North End community newspaper, right?
Free community newspaper where she's making $20 to $40 an article.
Right.
She admits in the case, she says that she wrote these articles because she sought to bring issues that she considered important to the attention of residents, politicians, and government officials, and to encourage public participation on such issues, and to cause government officials to take note of them. She said that writing the articles, quote, implicated and gave expression to her personal interests as a member of the community.
But silently. I mean, she also said she was trying to be objective and present both sides. I mean,
what we have, and that's not distinguishable from this case, if you look at the article at issue, we have an article that's appearing under the Huffington Post masthead that holds Sherry Foytlin out as a journalist, says she's a journalist on the article.
do you suggest that the Huffington Post masthead means that everything in there is just reporting the news, just the facts, ma'am, just the facts?
No, but I think it's circumstantial evidence of how any reasonable reader would read the article.
Huffington Post? Really?
Yes, Your Honor, and especially because we have, at the beginning of the article, it says Foytlin is a journalist, and at the end of the article, that is re-emphasized by saying Karen Savage contributed to the article. The article itself holds itself out as a news article, and
So if it was not petitioning activity, trying to get people to one side or the other, why did Chemrisk care about it? I mean, you didn't like it because they were advocating for a specific position, right?
To be clear, though, why Chemrisk cared about it is because Foytlin and Savage made false statements accusing Chemrisk of having committed fraud back in the 90s. Chemrisk has no skin in the game on any of the issues that Foytlin and Savage are involved in protesting or petitioning today. So that's, just as a factual matter, the record reflects that. Chemrisk doesn't care about any of those things. What Chemrisk cares about is having people make false statements of fact, accusing its scientists of committing fraud. And that's why they brought this suit. And I would say, too, when Chemrisk decided to bring this suit, it relied on the unanimous decision, your Honor's decision in the Superior Court deciding Fistolo versus Hollander, which was affirmed on appeal unanimously by this court, saying that the salient and dispositive point is that Hollander was not seeking to petition the government to redress a grievance of her own. That is the salient and dispositive point. And so too here. There's nothing on the article, which holds itself out as an article, that disclaims it as, we are representatives of an activist organization, we are engaged by BP cleanup workers. There's nothing that says that. It says we're a journalist, we're a contributor to an article, we're reporting on facts of specific cases, we're quoting people. It presents itself as a piece of investigative journalism, and anybody reading the article would take that opinion away from it because you're making several specific assertions of fact. The other thing I would say about Hollander,
Is it that, do you think that articles don't have as a purpose getting people to act on a particular belief?
no, I don't think that, Your Honor, at all.
So why wouldn't this article be considered in that way?
For the exact same reason that Hollander's articles weren't. So Hollander wanted to enlist public participation, and unlike in this case, Hollander's articles actually did spur the type of public participation she was hoping for. Her articles actually spurred the community to put such a wrench in the developers' applications that the development projects were killed. There's no evidence that this article in the Huffington Post had any such impact. But as this court unanimously held in Fostola versus Hollander, it doesn't matter if you're trying to get people involved in the issue. The salient and dispositive point is, are you trying to get them involved in an issue to petition the government to redress a grievance of your own? And that's not the case here.
So
Are you
that somebody's, go ahead.
Are you suggesting that because they're not BP workers, it can't be their own issue?
No, I think there's a little bit of daylight. Had Foytlin and Savage said, we have been engaged by BP workers, or we are the head of Bridge the Gulf organization, and we are speaking out as activists of that organization. If they have a blog that they contribute to, the Bridge the Gulf blog, it's a nonprofit organization that they post on, that would be a very different circumstance than when you publish an article not disclosing that you're an activist, not saying this is my opinion, not writing in the first person, writing in a third person about facts that you're saying actually happened, holding yourself out as a journalist and holding out your piece as an article.
So when you say you must petition with regard to a grievance of your own, would a community organizer be doing it for her grievance or for the grievance of the community?
It depends. I think this court's jurisprudence on this is pretty clear, right? So we have the Carpenters Union case in the town of Hanover, right? So if you're an association, obviously you can, you can advocate and you can speak on behalf of the members of your organization, right? You can file a lawsuit on behalf of the unionized carpenters. You can do that sort of thing. That's not the fact. Those aren't the facts of this case. So it depends. And I think what's really important about the Fostola decision is the court specifically addressed this argument because Hollander was an anti-development community activist. So that's what she was. And the court said, just because she does that, just because she is a community activist, and just because she wrote these articles to express and encourage public participation, her activist activities don't convert over and transform her article into petitioning activities that are protected under the Massachusetts anti-SLAPP statute.
So what do we do with the judge's finding with regard to the jurisdictional motion, which he appears to have adopted and incorporated into his SLAPP motion?
The finding actually supports the anti-SLAPP decision. So what he said was, and I can pull it up from the record, but he actually...
I've got it in front of me. Foytlin and Savage wrote and posted the article as part of their work to influence ongoing government proceedings and court cases regarding the oil spill and its cleanup, and to advocate that the government protect and compensate cleanup workers for damages caused.
Cleanup workers. And so because they are not advocating for their own interests or petitioning the government to redress a grievance of their own, it does not extend to them.
It's a pretty narrow interpretation, isn't it? I mean, means that anybody who serves as an advocate for somebody else, it's not their own grievance because they were not cleanup workers themselves, and therefore,
So the language of the anti-SLAPP statute itself actually requires that. So California has a very broad anti-SLAPP statute.
which language are you pointing to?
So I'm pointing to the same language that this court pointed to in the Coburn decision in 2005. So the language, and this is quoting from this court in Coburn, we read the phrase, quote, based on said parties' exercise of its right of petition under the Constitution, unquote, as restricting the statute's coverage to those defendants who petition the government on their own behalf.
Well, but okay, but why can't they petition the government on their own behalf that their dying wish would be that there be justice, as they see it, for the BP workers? Why isn't that on their own behalf? Just because they're not BP workers?
It really is no different than in Hollander. So Hollander was a member of the community. She was an advocate.
She was a regular, wasn't she also a reporter for that newspaper?
So yes, she was a free community newspaper. She was, made $20 to $40 an article. She'd also, unlike in this case, put her readers on notice that she was an activist member of the organization. So she had published several articles before the article that came up at issue in Fostolo, and saying, as a member of this organization, these are the things I'm advocating for. Those are the sorts of things that would fall within the protection of the statute. So her readers were actually on notice that she was an activist and so forth. But when she took that hat off and held herself out as a journalist, like Foytlin and Savage have done here, the activist activities did not transfer over. And Chemrisk, frankly, relied on that unanimous decision of this court in determining, when and where and whether to seek to have these statements corrected that its scientists committed fraud. There was, I think what the defendants or what the journalists are asking this court to do is really something quite remarkable. Massachusetts has an anti-SLAPP statute that has the specific language of its right to petition. This court in 2005 said that language means the statute only extends to people petitioning on their own behalf. Several courts in the interim applied Coburn and found that the anti-SLAPP statute does not apply to cases such as this one. And then Fostolo came up and was unanimously decided. In looking at that case, I really think that the only ways in which it can be distinguished actually make it a closer case than this one, because there was notice to the readers that this was in the same paper saying this person's an activist and represents this organization. So I think there would be a real fundamental unfairness here to say, to do what the journalists are asking this court to do and say, this has been the law of the land in Massachusetts since 2005, was made very clear in 2010. The legislature could have amended it. Senator Cream in 2009 actually introduced a proposed bill to broaden the Massachusetts anti-SLAPP statute, and the legislature did not pass that bill. It died in committee. No further action has been taken. So if this court's interpretation of the anti-SLAPP statute, unanimous decision interpreting it to only extend to people who are petitioning the government to redress a grievance of their own, if the legislature didn't like that interpretation, it's had 6 years to change it since Fostolo, or really it's had 11 years to change it since Coburn. The legislature has decided not to do it. And what the journalists are asking the court to do is usurp the legislature's role, amend the statute.
Maybe they thought that it wasn't necessary to amend it.
I think
because it's broad enough already. Maybe that's why it didn't pass, because the majority of the legislature thought we don't need to do this.
Well, I think that's probably right. They didn't, because the statute as it exists and as it's been applied in this court is broad enough. Journalists and bloggers and everybody else already have extraordinary protections under the common law of defamation. For example, in the United States Supreme Court's actual malice standard articulated in New York Times versus Sullivan. There are ample protections for people that already exist under the common law. And this court is really, this case is really about whether this court should usurp the legislature's role to rewrite a statute, upend years of precedent, and retroactively apply a procedure that Judge Young in the federal district court here has recently questioned its constitutionality. So, you know, I think that Chemrisk and other parties are entitled to rely on the law of the land that existed at the time they filed suit and not have the rules of the game changed after the fact.
Let me ask you a question that your brother answered. Imagine the possibility that you lose on the petitioning. Then you would need to show that the petition was devoid of any reasonable factual support or any arguable basis in law. Your brother says you've waived that, and therefore the only issue in the case right now is the issue of petitioning. Do you agree with that?
I don't agree with that for two reasons. Number one, there's a reason why we did not specifically brief and try to gather evidence and submit a bunch of additional affidavits and so forth. Fistolo was so clear that the anti-SLAPP statute did not apply here. So that's why we didn't argue it. But even though we didn't expressly raise it, if you look at Judge Young's recent decision, applying the type of, interpreting the statute in a way that is constitutionally permissible would require the court to, would require Chemrisk to only make a prima facie showing that there was no reasonable basis. I believe that we've done that. Our complaint attaches a letter from the scientist who Foytlin and Savage accused of having his data fraudulently misrepresented. We've attached to our complaint evidence that that's not true from the source himself, from the scientist who collaborated with Chemrisk. So, you know, we didn't raise it expressly, we didn't brief it because Fistolo was clear. However, there's evidence in the record that satisfies Chemrisk's prima facie showing that the people that were actually involved in this have something very different to say about it than what Foytlin and Savage alleged.
But in an anti-SLAPP context, in order for you to prevail in defeating this motion, you would have to not only have a prima facie showing, but the judge would have to find, based on an evidentiary hearing, that the petition was devoid of any reasonable factual support.
Well,
it's not merely that you have made a prima facie showing. The judge has to have a hearing on the motion to dismiss. It's a different type of motion to dismiss than the usual motion to dismiss.
I understand what you're saying, Your Honor. My reference to prima facie showing was a reference to Judge Young's recent decision wherein he said because of the constitutional right to a jury trial, and he was addressing federal law, but Massachusetts likewise guarantees that factual findings will be made and determined by a jury, not a judge. So in order to interpret the Massachusetts anti-SLAPP statute in a way that is not unconstitutional, that the preponderance of the evidence standard won't work. And because we need to interpret statutes in ways that are constitutional, that the only showing that needs to be made is a prima facie one in order to render the statute not unconstitutional.
But you've not made a constitutional argument. Are you asking us to reach that issue?
No, Your Honor. I'm asking you to affirm the lower court's decision, which I think is well-grounded in Fistolo.
Okay. Thank you.
Thank you. Justice Botsford, did you have a question? No.